will include legislature and the executive both, state, we can say. Now, this negative idea was apt for the American Constitution because American Constitution was drafted in an atmosphere of what you may call mistrust and distrust towards the government. But when we come to India, our constitution is a document of aspirations. We drafted it with lot of optimism, lot of faith, lot of belief, having dreams in our eyes. We wanted to change the status quo. So the question arises, the brand of constitutionalism, which was excuse me, advocated under the American constitutional system, is it suitable for India? Then another brand of constitutionalism is what we may call positive constitutionalism. I just mentioned about negative constitutionalism, where the focus is to put limits on the powers of the state, that is executive and legislature mainly. And not talking about what the government should do, what government should not do, not to violate fundamental rights, not to violate separation of powers, not to violate rule of law. But when we come to India or Indian constitution, we find that this kind of theory of constitutionalism is not suitable for the interpretation of the Indian constitution. Question arises, why did we make our constitution? We took 3 years, almost 3 years to draft this constitution. Whether the purpose was only to bind the government, that you cannot do this, you cannot do this, or we wanted to tell the government that you have to do this. We have elected you, we are constituted India into a republic, into a democratic republic, and we want to have justice, equality, liberty, dignity, fraternity. Why? Because we want that we must have some kind of change. The status quo is to be broken. And for that purpose, we established a government which will work. And if we want a government to work, we will have to give certain powers. So if you compare our constitutionalism or even the constitutional document, you will find that the American Constitution was based on a very limited idea of government, whereas our constitution or our system is based on a very expensive idea of government, because we were going to establish a welfare state. And that is why you know that we have directive principles of state policy. You know, American Constitution doesn't have this directive principle of state policy. There are many other constitutions, mainly European, Western constitutions, you can say, liberal constitutions of 19th century or afterwards also. They didn't have any idea of directive principles of state policy. Why? Because they wanted to keep the government in check. And for that, they invented many doctrines: separation of powers, rule of law, rights, federalism, like all these uh, principles, they operate to limit the powers of the government. But when we wanted to form a new India, we have established in India a democratic republic. For what? To secure, preamble says, to its citizens justice, liberty, equality, fraternity, dignity. And who will achieve it? Through which we will achieve it? We said that the constitution is a kind of an instrument which will be used to break the status quo, and we will achieve social justice, freedom, equality, dignity, fraternity, all these things. So when we look at the constitution in this way, we cannot adopt that negative constitutionalism which is prevalent in the United States of America and in European states. We wanted something else. And that is why our constitutionalism is very different from the constitutionalism of Western countries. Our constitutionalism has been recently, it has been recognized, and you are very familiar with that doctrine, transformative constitutionalism. Our constitution is to transform, transform the society, transform the economy, transform the basic structure of the society. That was not the purpose of the American, that is the USA Constitution. They wanted to have a government only with limited powers. But we have a big agenda in directive principles of state policy. We wanted to achieve what Granville Austin says, social revolution. The very interesting thing is that in the USA, France, USSR, in China, first the revolution happened and then constitution was drafted. American constitution was drafted after the war of independence was won by Americans against the British. Then they drafted the constitution. Likewise in France also, when the earlier setup was broken, was replaced through what you call French Revolution, then they drafted the constitution. But the Indian constitution was not a result of any revolution. Conversely, what we wanted, that we will have a constitution in a very peaceful manner, and then through this constitution, we will have social revolution. So, Indian constitution is a document of social revolution. Austin says, Granville Austin, not John Austin Law is the command of sovereign wala nahi. Granville Austin, who has written a book on constitution, 2 or 3 books on constitution of India. How it can be achieved? It can be achieved through various mechanisms provided in the constitution. For example, take fundamental rights. Preamble, you have seen, preamble is also revolutionary in nature. It declares that we, people of India, have established into India a democratic republic for what? For securing justice, equality, liberty, and so many things are written. So it's very clear the preamble is revolutionary in nature. It is not neutral. It is not neutral. It is biased, you can say biased in the sense it is tilted in favor of the weaker sections of the society. The American Constitution is more or less neutral. It talks about the governments only, but Indian Constitution talks about the weaker sections, women, and all the marginalized sections, minorities, and other sections of the society. And we wanted to bring a change. So Indian Constitution, through its preamble, you can see that it is value loaded. It is not neutral, value free. It is with values and values of social transformation. Fundamental rights. Next, you see Article 17, for example. What does it say? Untouchability is abolished. It has not happened anywhere that a particular action or act is made punishable. It says untouchability is abolished. Its practice in any form is forbidden and then it is punishable also. It is not the function of the constitution, you will see. But in the Indian constitution, you find Article 17, then you have Article 15, Clause 2, where the public places, public park, places of public resort, public entertainment are open to all. 23, right against exploitation, that is no exploitation, no begar. 24, relating to children, that is there. Article 25 says the Hindu institutions of public character, that is temples you can say, they are thrown open to all sections of the society, Hindu society. That is no untouchability even in the temples also. They are thrown open to all. That is revolutionary. That is that it wants to bring change. So the nature of the Indian constitution is transformative. Then you come to directive principle state policy and fundamental duties also. Fundamental duties are also transformative, that you change. When Dr. Ambedkar presented this constitution, he spoke about constitutional
Right.
morality, that this constitution will work only if we have constitutional morality. And then he says, it's very important to know that constitutional morality is not a natural sentiment. We will have to develop it. It is an artificial sentiment because Indian society was very much against, in through its practices, through its customs, against women, against other sections of the society, LGBTQ, against disabled. There were so many social evils. So it is made clear that we will have to change. We will have constitutional morality against the public morality. Public morality or societal morality is different. We will create a new morality, and for creating this new morality, we will have this artificial sentiment, and then laws were enacted. For example, atrocities against SC and STs, a law is there. Domestic violence, a law is there. There are so many laws which have been enacted to curb this many social evils. Why? Because we knew it that we have not developed a morality in favor of these sections of the society. That's why we will have to develop it through fundamental duties, through directive principle state policy, and then we will move further. So that means that we will transform the society. We have to remember one thing, that in most of the European countries and USA, China included, USSR, France, everywhere there was transformation of the state. The state was transformed from monarchical to democratic. Indian constitution is different. It is not speaking about the transformation of the state. It is speaking about the transformation of society. We wanted to transform the society. And for that, we have enough provisions in the constitution of India. So we have preamble, we have fundamental rights. Rights means what? You confer rights. But in the Indian constitution, duties have been conferred. That is, no untouchability, no beggar, no discrimination with women. Article 15, clause 3, no exploitation. Temples will be open to all. All these things were included in the provision. So the nature of the Indian constitution in itself is transformative. So we could not adopt that brand of constitutionalism which is prevalent in Western countries, because we wanted to transform the society. That is why sometimes our constitutionalism is called as positive constitutionalism, ethical constitutionalism, or now we have given a name to it, transformative constitutionalism. And we have taken this idea from the South African experience, but I will not go into that. So you have seen that our constitution is basically a document of change, a document of a social revolution, a document of aspirations, faith, belief, and this has to be done, achieved, realized by all the sections of the society, including the government and the people also. When we say untouchability is abolished, it is not only against the government, it is people to people. There are relationships which are maintained in the constitution from top to bottom, virtue that is vertical, state and citizens. But we have citizens to citizens, that is horizontal application of fundamental rights. And that is Article 17, that is Article 15, Clause 2, that is Article 23, exploitation, 24, children, 25, all these are citizen to citizen. So we wanted to have that. So this constitutionalism, or you can say constitutional morality, is not applicable only on the government, but on the citizens only. Also, and in the constitutionalism in USA or in Western countries, it is relationship between the state and the citizens. Vertical, only vertical. Ours is not only vertical but horizontal also. Now, how it can be achieved? For example, in United Kingdom, England जैसे बोल देते हैं, there is no codified constitution, or some say unwritten constitution, though a good part of this it is written, it is in various statutes. So but it is not codified in a single document like we have in India or in the USA. So we say that it is unwritten constitution or uncodified constitution. You know that parliament is supreme there. Okay, parliament is supreme. That means that the laws enacted by parliament, British parliament, cannot be struck down by British courts, British Supreme Court. Earlier it was House of Lords. So how do they achieve constitutionalism? They have a unique doctrine there. That is rule of law. Rule of law means law will rule. People or the men will not rule. So rule of law means who will rule? Law will rule. Of which law? That is in the statutes. So that makes the constitution. So they achieve their constitutionalism through parliament because the courts are not powerful like you see in India or in the United States of America. So they have achieved their constitutionalism through people's participation. That is popular constitutionalism, people's constitutionalism, and it has 800 years old history, starting from 1215, that is Magna Carta. But we don't have that. So how do we ensure transformative constitutionalism? If the state is not, that is the parliament or the government, they are not taking this constitution forward to have social revolution. For that, we need judicial review. What is judicial review? Now, judicial review is basically reviewing the constitution, reviewing the legislation, and seeing that they match or not. Very simple. But now we talk about a living tree constitutionalism, sorry, living tree judicial review. That is, we take this constitution as a living tree, that it is always growing. It is always growing. So our judicial review should also change with the time. Now, how we have achieved constitutionalism in India? In the initial years, it was more or less negative constitutionalism. For example, if you can recall, Keshwanand Bharti case, 1973. In Keshwanand Bharti, the Supreme Court declared that the basic structure of the Constitution cannot be destroyed. You cannot, that is, you cannot destroy the basic structure. What does it include? Separation of powers, federalism, democracy, all these basic features cannot be destroyed. What you can do, what you should do was not there. This is a kind of a negative constitutionalism. The things started changing from Menka Gandhi case, which came in 1978. It came after emergency. We have seen during 75 to 77, during emergency, that the fundamental rights could be violated, the constitution could be trampled. So the judiciary became very allied to the demands of the people, that we the people of India have enacted this constitution. So in Menka Gandhi case, an idea of what you may call natural law was infused in the constitutional adjudication. You know, in A.K. Gopalan case in 1950, when we started with this constitution, it was held that the procedure established by law need not be fair, just, and proper, because it is not written in Article 21, the right to life and liberty. But in Menka Gandhi, the things changed. In Menka Gandhi case, the Supreme Court declared that if the constitution, if the procedure is not fair, is not just, is not proper, reasonable, then it is no procedure at all. ये law है ही नहीं. Law should be just, fair, and proper. This was the beginning of, you can say, transformative constitutionalism. That is, the interpretation of the constitution changed. And then came an idea, and which was implemented in India, and India was pioneer in that, that is public interest litigation. Article 32 said that the fundamental rights are to be implemented by the Supreme Court. Eh, But it was not specifically written that the person whose rights have been violated, he would approach the court. It was simple that the Supreme Court will enforce the fundamental rights. So idea of PIL was invented, that if the fundamental rights are being violated of a group, of a section, of a marginalized section, then any person, public spirited person, can approach on behalf of that particular group, because they can't come to the Supreme Court or the High Courts, and then the fundamental rights can be enforced. It was revolutionary in nature. And then you say that Article 21 was expanded and right to education was read into it, because it is directly related to life. Right to education was a directive principle state policy. It was not a fundamental right under Article 45. But when this Supreme Court realized that the free and compulsory education is not being offered, is not being given to the children, then they interpreted this constitution in a very transformative manner, and they read in Article 21 in the phrase that is life, that if education is not available, then meaningful life is not possible. So life does not mean animal life. Life means a human life where a person can have, can realize the potential of his intellect, his wisdom. And that is possible only through education. Education is a vehicle of progress. It is a basic need that was read into Article 21. So this kind of review, judicial review of Article 21 was a people-oriented review. And this was transformative judicial review. Though at that point of time, nobody talked about transformative constitutionalism. But transformative constitutionalism has already come on the scene, and it was having its impact on the interpretation of the constitution. And then you see through PIL, we have and other interpretations of Article 14, 19, 21. We had many species of rights which were not written in Article 21 or 14, which were though written in directive principle state policy, but nothing was happening. So the Supreme Court and the High Courts also read into it right to education. That was read first by the Supreme Court. Then Article 21A came, and then this law, Right to Education Act of 2009 came. Right to education, then right to shelter, right to livelihood, right to environment. Numerous rights were read into Article 21. And after Menka Gandhi, rights were made available to accused, to prisoners also. That means that if you are in the prison, behind the walls of prison, it doesn't mean that you will not be treated as a human being. The fundamental rights, the basic rights will go into the jail also. So even prisoners, detainee, convicts, all had some certain rights, and they were invented, discovered by the Supreme Court, making use of the broad language of Article 21. So transformative constitutionalism was possible only because of PIL, expensive reading of Article 21, and a big chapter on directive principal state policy and preamble also, and then fundamental duties, So all these rights were made available by the Supreme Court and the High Courts. It doesn't mean that the state did not do anything. I am focusing only on judicial review. The state was also doing. For example, it enacted right to information, it enacted right to food, law, and then it enacted many other acts also in the last 20 years, which implemented directive principal state policy to transform the society from the basic level. Domestic violence law, law against the atrocities, which were atrocities committed on SC, ST, the law was enacted. To safeguard the interest of women, many laws were enacted, but even then, the state was not progressive enough. So, two, three examples I may give where the Supreme Court had taken lead, and that is why this phrase transformative constitutionalism came into practice. We started using very much. So, if you can recall Vishakha case, in Vishakha case, can anybody tell what was Vishakha case? Am I audible?
Sir, Supreme
Very
Court laid
important.
down guidelines regarding sexual harassment.
Right. Okay. Good. So before Vishakha, there was no law which dealt with sexual harassment of women at workplaces. Now, if sexual harassment of women is taking place at the workplaces, it is violation of Article 14 and 21, both other articles also. How? If a woman is sexually harassed at the workplace, what would she do? She would stop going there. If she stops going there, then her livelihood is challenged. She can't earn. If she doesn't have livelihood, then you can understand that her level of standard of living of the family also will go down. Her prestige, her independence, financial independence will also be severely restricted. So this kind of act was having impact on her enjoyment of right to life. 21, and only women are sexually harassed, not men. It violated Article 14, right to equality also, but there was no law to take care of it. So Supreme Court in Vishaka case declared it as violation of fundamental rights and provided the guidelines also. So it was a kind of a judicial legislation. It was criticized also because it was judicial activism, but it was transformative constitutionalism also, positive constitutionalism also. And you know that after some time, the law was also enacted. So Vishakha case is a very classic example of transformative constitutionalism by the judiciary, because I am talking about judicial review. That that Article 21 and 14 also were reviewed judicially in such a manner that the spirit of the constitution was captured. That the preamble says, we the people of India. We the people of India would include women also, other sections of the society also. So why their interest should not be safeguarded? And that is why this Vishaka case came. We were ignorant about that, or we were oblivious to this kind of happening. Then we can discuss Nalsa case, 2014 case. Nobody knew, or rather, we can say they were there, but they were invisible minority. That is LGBTQ. Now, LGBTQ, nobody bothered about them. They were living in the society. They were ridiculed. They were harassed by police, and they were not taken in the mainstream. They could not get job also. But the Supreme Court in Nalsa took note of Article 21. Person, every person, not only Indian citizen, but the foreigner also, 21 is available to them. Article 14, not only to citizens, it is available to non-citizens also. And here, LGBTQ, they are citizens of India and they are being harassed. So in Nalsa, third gender was recognized because in the USA, Trump says there are only two genders. But this is not natural. There are three genders. So that third gender was recognized, and then they went further. They knew this exploitation or discrimination will continue. They provided that they should be declared as backward classes so that they can get benefit of reservation in employment, in education also. We are moving very slowly, but we are moving. It is a kind of a transformative constitutionalism where we are transforming the society, not the state. The judiciary is interested in transforming the society. Why? Because the state is not taking due care of all these things. Then, Puttaswamy case, Justice Puttaswamy case, right to privacy is very important. But for the last 50, 60 years, nobody bothered about it. The right to privacy is not a fundamental right. But now, right to privacy is a fundamental right. That means sexual orientation also means that is also right to privacy. And that is why we have Sabrimala case. In Sabrimala, sorry, in Navtej Johar case, Article Section 377 was removed, and this homosexuality was decriminalized. Why? It is again extension of right to life to these people. This is Section 377 says unnatural. How it can be unnatural? Third gender is natural. We do not make it. Nature makes it. So whatever sexual orientation is found in LGBTQ, that may be referred back to God. We cannot say that it is unnatural. It is natural, and there can be medical. I mean, operation also. That's I don't want to go into that. So, Navtej Johar, a minority of homosexuals, was given relief. It's again example of transformative constitutionalism. Then Sabrimala. Sabrimala, though there is a dispute about it, I have also some objection about that. But what is the importance of Sabrimala? The importance of Sabrimala is that women cannot be discriminated even in the religious places. Because so far we thought that when we are talking about women, they will not be discriminated in political sphere, in social sphere, but they were exploited or discriminated, I can say, in the religious sphere. That is Sabrimala temple. They were not allowed, the girls from 10 to 50 years age, and it was allowed. It was interference in religion. Domestic violence, that is also a case, though law came first, but that is also there that even in your home, constitution will go. Home is not away or can be said that it is a safe from constitution. It is also within the province of constitution. So constitution reads the home also. That is that domestic violence will not be allowed. So then the abortion, I can't go further into it. In abortion law, that even the law provides a particular time period after which abortion cannot be obtained, 24 weeks. But you have seen many decisions of the high courts and sometimes Supreme Court also that they allow. Because laws should not bind. Article 142, complete justice is to be done. And Article 142 has been used for transforming the society because the signature tune of our Indian Constitution is transformation, social justice is the signature tune of the Indian Constitution. So we have to change the society through the Constitution. In that sense, Constitution becomes an instrument. It is to be utilized by the state But if it is not being utilized by the parliament and the government, then the Supreme Court will do it. And that is why the judicial review from A.K. Gopalan has changed from A.K. Gopalan to Keshwanand Bharti case, then Menka Gandhi and PIL, and then recent cases Vishaka, Nalsa, Puttuswamy, Sabrimala, Nafte Johar, Babita, in army also given will be granted commission. All these cases you will find in last 10 years, they reflect the transformative spirit of the Indian constitution, and it is being achieved through judicial decisions. And because my focus was on only judicial review, so I stop here and the session is open for questions. Thank you very much.
To all the attendees, do we have any questions for sir? We'll just have a very brief question answer round. You're requested to please drop your questions in the chat box if there are any.
They are waiting for dinner.
Yes, sir. We're waiting for the questions. If there are any, the attendees are requested to please drop them in the chat box. So we have one question. It says, what is the difference between procedures established by law and the due process of law?
Okay. Process includes the substantive part of a law and procedure part of law. As you know that you have Bharatiya Nyaya Sanhita, it was IPC earlier, substantive law, then CRPC of procedure. So in the United States of America, we have due process of law. Process includes there in the United States of America, that is Fifth Amendment, the procedure and the substantive part of law. That is, the American Supreme Court, according to the Constitution, would not only review the procedure through which liberty is being taken away, but it would also go into the substantive part of it also, why liberty is being taken. Then we come to procedure. The Indian Constitution to start with, and that was approved in A.K. Gopalan case, talks about procedure only, not process. So substantive part of it is out. Law may be unreasonable. And then it was not qualified with due procedure established by law, only procedure. So Supreme Court said in A.K. Gopalan that we are not going to look into whether this part, that whether procedure is just proper, fair or not. We are going to look into whether the procedure established by law has been followed when a person's liberty is being taken away, not further. But in Menka Gandhi case, the Supreme Court said that if the procedure is not just fair, proper, reasonable, then it is no procedure at all. That means it is introduction, infusion of word due in our constitution also. So, practically speaking, now there is no difference between due process of law and procedure established by law under Article 21 in India. It is also through judicial interpretation.
So we have just one more question before we let you go. The question is, how do we protect constitutionalism against the efforts of an unruly state to deteriorate the constitution itself? Can we use the sword of constitutionalism as a shield?
Constitution is available as a sword and as a shield also. But much depends upon the judges also. Uh, there were times when the judges invented PIL. We can recall Justice Krishna Iyer, Justice Bhagwati, Justice O. Chinnappa Reddy, Justice D. A. Desai. They were very much concerned with the plight of the people, and they tried to regulate or control, you can say, the arbitrariness of the state. Now things are different. The Supreme Court says that electoral bond is unconstitutional, but the result is zero. In Anuradha Bhasin, they say that internet is the fundamental right. It's a Jammu Kashmir case, but the result is zero. So there is a difference between review and remedy. Earlier, you will find when PIL developed, there was a strong review and a strong remedy also. Vishakha case you can take, Nalsa case you can take. But now, if there is a strong review, the remedy is weak. For example, you take electoral bond case where the review was very strong, unconstitutional, but the remedy was very weak. And many a time, the review is also weak and remedy is also weak. So we have seen last week about the power of governor to stall or give assent to the bill under Article 200. So much depends upon the judges, because the if you can recall the words of Dr. Ambedkar, that we can have a very good constitution, but if the people who are running it or we are working, they are not good enough, then this good constitution will also be a bad constitution. Or if we have a bad constitution, we can make it a very good constitution. For example, USA had a very small document, but the kind of liberties, the kind of freedom that is available there, in that is because of judiciary. It depends upon the judges, the human element. The constitution does not operate by itself; it is operated by humans. Yes, next, please.
Sir, I think that would be all. Thank you so much, sir, for your very insightful and knowledgeable lecture. It was indeed our sheer pleasure to have heard you highlight the nuances of this very wondered about topic. And who better than you, sir, who's an authority on Constitution, to have shown light on this. Allow me, if the audience would be patient enough, sir, if you would just allow me to thank you. Well, so you have an extensive body of work, including teaching experiences at various universities, and you've also served as the first academic council of NLS Bangalore, and you were nominated by the Chief Justice of India himself to the Executive Council of the Indian Law Institute. Apart from having published dozens of chapters and papers in reputed journals, Sir has also contributed to the Government of India's e-Pathshala project. And it was our absolute pleasure and honor, Sir, that you very kindly and graciously accepted the invitation of our very humble initiative. And we thank you so much, sir, for this robust lecture. It was indeed our pleasure to have you. We would love to host you another time. And thank you so much for your valuable time. Thank you so much, sir.
Thank you very much, all of you. You have given me patient hearing, though it's night. Okay, thank you very much. Good night.
Thank you so much, sir. Thank you.
Okay, may I sign off?
Sure, sir. Sure, sir.
Thank you.
Thank you.
Thank you. Bye bye.
The audience is expected to stay back. We have another lecture, which is the keynote address of the webinar by Professor Ghayur. Now over to Tanzeel for the same.
We just we're just waiting for the honorable professor to join us. We'll be resuming shortly.
ये इसको थोड़ा सा बड़ा करो थोड़ा सा।
Good evening, sir. Am I audible?
Good evening. Good evening. Am I audible?
Yes, sir. Yes, sir. You are. Good evening, sir.
Good
We are
evening.
grateful to have you with us, and it is my absolute pleasure to be able to introduce you to our audience for today's keynote address. While it is an extreme honor for me, it is also a dilemma because where do I begin and how do I begin to like with the endeavor of introducing you? Perhaps by quoting Shakespeare, yeah, from the play Julius Caesar would be a good way to go. His life was gentle and the elements so mixed in him that nature might stand up and say to all the world, this was a man. For all the participants, Professor Ghayur Alam is the senior most professor of law at the National Law Institute, University Bhopal, NLIU, India. He is an alumnus of Aligarh Muslim University and the senior most professor. He is also a senior professor by designation. His support to newborn initiatives is not just evident from his support to the NLIU Bhopal, but also from the fact that he is also the senior editor at Virtuosity Legal. Today, in offering these words, I do not merely introduce him, I pay a tribute. Professor Alam, an alumnus of Aligarh Muslim University, stands as a living embodiment of the AMU Tarana itself. जो अब्र यहाँ से उठेगा, वो सारे जहां पर बरसेगा. A cloud rising from Aligarh, carrying wisdom across the world. Professor Alam, we welcome you to today's address. The stage is all yours, sir.
Thank you so much, Tanzil, and thank you, Mahvish. Good evening to every participant. The theme for this discussion is constitutionalism, understanding constitutionalism. And then I'm not able to see the whole title. Mahvish, can you read it out, what it is? Because it's not visible. The whole of it is not visible to me.
The title is Understanding Constitutionalism, Tracing the Dynamic Evolution and Qualification of the Very Doctrine.
Okay, thank you. And I would like this interaction or this discussion to be interactive. If there is any question, and I do not know the modalities, whether the participants have to ask the question in the chat box or they have to do so directly. Whatever is the manner, if there is any question, comment, suggestion, particularly disagreement with what I'll say, please intervene and express your opinion on that. So I'll begin with the word understanding. So how many of you can say, and mostly what I understand, participants are students, right? So how many of you understand the meaning of understanding? And how many of you can explain the difference between understanding and comprehending? Anyone who'd like to say something on that? That when we are trying to understand anything for that matter, so we must know what we are going to do for 60 minutes or so.
Professor, I believe that if we are to say what understanding means, I would say, like in my limited understanding of the word itself, it's something that is a result of an inner conflict. Something that we understand is something that challenges our existing state of knowledge. And once we take it up as something novel and we imbibe it, and that is how we end up with the word.
Thank you, Tanzil. Compare had chipped in because perhaps no response was coming. But one thing that this question cannot be answered on the basis of belief. This can only be answered on the basis of knowledge. As I understand the meaning of understanding, it is at two levels. One is at the scientific level, and the other one is at the normative level. Scientific, understanding anything as it is without coloring it with one's value judgment, with one's preferences, liking, disliking, prejudice, love, hate, whatever, as it is. And for that, that is um, maybe constant or maybe varying with time. So one level is scientific, that constitutionalism, what it is. And when we talk about any ism, be it communism, be it socialism, be it secularism, be it whatever ism we talk about, and Mahimish, I'll also request you that at least some of the participants must switch on their video, because I find it difficult to speak to an empty screen. So at least some of the who are on the first screen, they should be visible, because that helps the speaker to speak. Otherwise, or I may be forming an image in my mind that there are people who are listening to me. So, if it is possible, that at least some of you should switch on your videos. So, constitutional is what I was saying. It is an ism. And when we talk about constitutionalism, are we talking about the constitution, or are we talking about the constitution? Right? Constitutionalism, whether it answers the question of constitutional law or it seeks to answer the questions about constitutional law. And when we use the expression constitution, right? Anyone who knows the etymology of the word constitution? Anyone?
Sir, constitution means giving a physical quality to something.
My question is, what is the etymology root word from which root the word constitution has come into existence?
Is it grundnorm?
Absolutely not. Because
Together to
and
set up.
please say whatever you want to say so that we are trying to understand, right? Because this is what the idea is: understanding constitutionalism, right? So that necessarily entails understanding constitution and the root word. Look, root is not the tree, because we are talking. I'm using the word root. That symbolizes life. Root is symbolize, though it is a metaphor, not in the literal sense. And if there is a root, right, there will be a stem, there will be branches, there will be sub branches, there will be leaves, there will be flowers, there will be fruits, right? So I'm talking about the root, that the root of the word constitution, right? And what constitution is called in Hindi, in Sanskrit, in Urdu, in Persian, in Arabic, right? The languages we are somewhat familiar with, in addition to English language, right? And where from this, whether it was Greek origin, Latin origin, French origin, or English origin itself, right? Because, and answering this question, please understand, in today's time is very quick, right? Internet, then artificial intelligence, then generative artificial intelligence. Right. Anybody who says that just types etymology of it or root of the constitution, you will find the answer. One need not take much of a time, right? Because this is something in when we were students, right? This facility was not available to us, right? In 1990s at Aligarh or at any other place in India, there was one computer center, but it was not as everybody is having a mobile, a laptop. There are so many devices, right? Now it's very easy to find that out, right? So first step is to understand the root. When we go to understand the concept, here the organizers call it a doctrine, right? Is it a doctrine or is it something else? And if it is a doctrine, then question is, what is a doctrine? Anyone who can tell me the meaning of doctrine without going into um, uh, anywhere or on the internet or asking AI? Anybody who knows doctrine, why do you call it doctrine? Why don't you call it a philosophy? Why you do not call it a principle? Why do you not call it a standard? Why doctrine? Anyone? Other point, that is dynamic evolution. Evolution um, necessarily is dynamic, right? That if it is evolving, that something evolves. So in evolutionary process, some new characters are acquired and some existing characters are jettisoned, right? So it is always plus minus. It is not merely plus plus. It is not merely addition. Evolution, right? As biologists say that humans now, we do have a tailbone, but that tail is not clear because it was there. That is also a part of evolution. Because what I guess that um, our fingers may lose the ability to write with pen after some time because we are not writing with pen and paper except for the examination. So anyway, so one thing is that is to be understood. Main point is constitutionalism, and then tracing the dynamic evolution, right? And what are the qualification of this doctrine? Constitutionalism, right? When we say, and some question, the answer of which you can find on your own etymology of these words. Doctrine simply means teaching, right? Learning, teaching, right? So, is it merely for the purposes of learning and teaching this idea of constitutionalism, or it is for a particular purpose? So, when we talk about constitution, right? So, who, what is the purpose of constituting anything? This means what? There must be some who has the ability to constitute, and the one who is going to constitute must have some material to constitute something. It may be a structure, right? Or the word statute is also, that is the root word if you go to the etymology of that, of the constitution, though it is the stature. So, constitutionalism. So, if I ask you about the Constitution of India, what is the meaning of Constitution of India? What is being constituted? Who constituted it? What for it has been constituted? Constitution itself answers that question. And what it says, that we the people of India have constituted this constitution. I'm not using the same words because the word constituted, the constitution does not appear anywhere, right? But the beginning word, we the people, and why we did so, is there some purpose, right? Because every constitution has a purpose, be it natural, be it artificial. So we must understand we are talking about artificial constitution. We are not talking about um, natural constitution. Artificial here simply means man-made or made by human being. In other words, we are talking about a secular constitution. Why I'm saying secular? One of the essence of secular is that it is by human beings, not by God, not by divinity, not by anything else, but we the people. We are talking about a constitution made by us for us. Made by us for us. And then, what are the constituents of that constitution? Certain ideas. Right? If we read the preamble to the constitution, that who we are, right? There are who we are as per the constitution. Anyone, any participant, who we are.
So we are the people of India.
Very good. And then what is India?
India is a union of states.
Good. Right? And then what the constitution tells us, about India. That what kind of India did we constitute?
Sovereign, socialist, secular, democratic republic.
Very good. 5 identities we have given to ourselves. Number 1, we are sovereign. Anyone who can tell me the meaning of sovereign?
So it's the external and internal freedom of a state to govern themselves according.
Very good. With one modification, internally supreme and externally free. Right. We are, in internal matters, we are supreme. Ramsha is saying something. So in internal matters, we are supreme, right? And we are free from the interference of anyone else. That is one. Then anyone who can explain the difference between socialist, capitalist, and communist, that we are socialist. Though there are several meaning of socialism, several flavors of socialism, but something which is common. That what is it that distinguishes all the three, socialist, communist, and capitalist? And these expressions refer to what?
So, if I may.
Please.
Yes, sir. So essentially, sir, in the manifesto, so they have Marx and Engels have used this communist and socialist word interchangeably. But essentially, when we say that we are a socialist state, we believe that the in the like equitable distribution of wealth, we believe that the wealth and the resources, mostly the means of production, shall not be the monopoly of a select few, which is essentially something that capitalism envisions. And so that is the kind of capitalism. And so the difference between socialism and capitalism is essentially accumulation of wealth and
What
the
is the
distribution of.
question? Tanzil, the question, what is the basis of distinguishing these three isms? Socialism, capitalism, and communism. Property.
So,
Property.
yes,
One
sir.
word answer is
Yes,
property.
property.
Right? So in case of socialist state, right, and what I'm saying, communism, socialism, even capitalism has several flavors, that it is not one meaning, there are several meanings. So property. In case of socialist state, state is the property is vested in the state. Like the property right, which is a constitutional right now, right? That is what? simply fee simple, right? It is not absolute right, because we can never exclude the state, right? We can exclude everyone else, but we can never ever exclude the state, because what it says, that save, right, according to the authority of law, every person, no person shall be deprived of his property, save according to the authority of law. Right? This means what? Everyone can be deprived of his property according to the authority of law. The only caveat is that there must be authority of law. Right? Communist community, capitalist private individuals. We are also going the capitalist way, right? So one of the questions is it constitutional? Can we do so without amending the constitution, right? And then secularism. There's a lot of debate on that. Um, that this has been added to the constitution by way of 42nd amendment. My response to that is there are other expressions which are used in the 42nd amendment to the constitution, and fundamental duties are also inserted by way of the same constitution, and there are several amendments till now. So if this is the argument, let us do away all the amending power of the parliament, let us go back to the original text of the constitution. That is my take on that, that if um, uh, so that is one. Then democratic republic, right? Republic simply means that the head of the state shall be elected, right? Not and democracy, representative democracy, election, and so on and so forth. I'm not going into the definitions of that. So we have five characteristics, right? When we talk about the who we are, what India is, right? And what for India is, what for we have constituted ourselves the way we have constituted us. Because when we are constituting, building something, right, building a structure, right, so we say that, look, these are three identities that we have. What for we have those identities, right? To ensure, right, number one, justice, right? Justice is first, liberty, and then you can go to the constitution, the preamble to the constitution, right? So that is what it is. When we talk about constitutionalism, right, there are several expressions and you must read about them. One is constitution, the other is constitutional law, the third is the law of the constitution, right? Anyone who can tell me the name of the author who wrote a book with this title, The Law of the Constitution, and what does it signify? The law of the Constitution, not law of the Constitution or law of Constitution, the law of the Constitution. The time you are taking that, in that time you can find it out on the net. So if
Sir,
the answer
AV
is coming,
dicey.
good. AV dicey, right? AV dicey. So constitutional law, law of the Constitution, constitutionalism, right? These three expressions. Out of these three expressions, when we talk about constitutionalism, the debate about constitutionalism is power centric. Now, my main discussion starts because this was just the background, right? So, when I said that the debate about constitutionalism is power centric, right? What does it mean? Anyone? कहाँ चले गए सब लोग? Nobody has switched on the video. During COVID, it was my instruction to my students that You are not allowed to switch off your video. If you do so, you will lose your attendance. Right? Here, no doubt you are students. I'm interacting with you for a few minutes. And if you are really interested, right, really interested to interact, you are most welcome. And if you are not interested, so be it. We are free individuals. We are free citizen of a free country, right? Let's not waste our time. And only those who are interested should be here. Why should we join any online lecture if we are not interested in it, right? I will not never ever join a lecture if I'm not interested, right? So Tanzil साहब कितने participants हैं? How many participants are there?
So we have 12 to 13 members from Virtuosity Legal, and rest everyone in the meeting is a participant.
No,
That's 38 people.
total number is how?
38 people.
So out of 38, can't we have at least 10 persons who can at least switch on their video?
Please, as sir is announced, please turn on your cameras.
And that must be done freely.
Yes,
Right?
please.
And my advice to the rest of the participants will be that please leave this. If you are not interested, please leave this. All right? Because we are free. I'm also free. It should not be simply a formality that look,
Dear participants, please keep your questions focused only around the lecture. Any disruptive questions henceforth will lead us to unfortunately remove you from the meeting. Please maintain the decorum in the meeting. Yes, sir. I'm really sorry.
नहीं कुछ और है तो वो भी बता दो. I'll take that question also. So what I said that the debate about constitutionalism is power centric, right? So anyone who can just say that this is what is the meaning of this statement. Power centric. Anyone who can explain the meaning of power. What is power? And please say whatever you think, right? Whatever is your
The ability
knowledge.
to control people.
Ability to control people. Very close, very close. Ability or capacity to change the position of others without their consent or will. Right. That may be physical power, that may be power of mind, that may be hard power, that may be soft power, right? That may be power of money, that may be power of muscles, that may be power of law, that may be power of constitution. But central point is that the ability to change the position of other, right? Now, we are discussing something here, constitutionalism, right? What is the purpose? That the speaker is trying to change the understanding about constitutionalism, right? And whether the speaker is successful or not successful depends on both the speaker as well as the audience, right? Audience must be willing to understand, and the speaker must be trying to make the audience understand, right? If both the conditions are fulfilled, so debate about constitutionalism is power centric. Number one, that is first proposition that I am making. Number two, constitutionalism is about creating power and also as well as limiting the power. Whose power are we talking about? We are talking about the power of the state in general, particularly the power of the government. How many of you have read Henry David Thoreau? Henry David Thoreau, who developed an idea, and the idea was then that the best government is the government which governs the least. Right? That is one. 19th century idea, though, from America, USFA. Best government is the government which governs the least. He developed this idea and he said that the best government is the government which governs not at all. Right? So when we talk about our constitution, right, what is that idea? Right? Is the idea of governance central to the constitution, or is the idea of service central to the constitution? Right? That be it legislature, be it executive, be it judiciary, three main organs of the state, are they there to govern the people, or are they there to serve the people? Then what is the constitutional idea? So when we talk about, when the debate about constitutionalism is power centric, right? The beginning or this idea neglects the obligation of the state or obligation of the government. That is my critique of the ongoing debate, right? Because they talk about power, that minimum government, maximum governance, right? My point is that the idea of governance is antithetical to the Constitution of India. Idea of governance is antithetical to the Constitution of India. And what is the constitutional idea? The constitutional idea is service. And if participants remember, the Prime Minister of India, in one of his speeches, what he said, that I'm not Pradhan Mantri, I'm Pradhan Sevak. Right? Pradhan Sevak. And that is the idea, right? Pradhan Sevak, that everyone, right, in the service of people of India, in the service of the Constitution. So if the Constitution talks about power, right, it creates power, it also limits power, right? Creating power and limiting power. Focus, if we talk about fundamental rights, right? A state is defined and then there are fundamental rights, and going to the Supreme Court. Fundamental rights, as I understand, in its nature is fundamental obligation of the state. That they are fundamental rights of the citizens, right? That means that they are fundamental obligation of the state. So the first thing in constitutionalism, in my view, is the identification of the obligation of the state and obligation of the government. That, in other words, what are the obligations of the legislature, be it union legislature, be it state legislature, right? What are the obligations of the executive, be it union executive or state executive? And when we talk about executive, we have go up to the level of peon, right? Because they are also part of the executive machinery, where a file is moving in time from one table to the other. So when we talk about executive, we should not be are thinking about political bosses and bureaucracy alone, we should also be thinking about the ministerial staff. Because when we talk about power, it is not only the power head, but the capillaries of powers also matter, arteries of power also matter. Similarly, in the same vein, what are the obligations of the judiciary? Right. And then, so what I'm saying, in constitutionalism, obligation comes first. And to carry out the obligations, we require power. That if we begin with power, that whether power first, then obligation, or obligation first, then power. So, what is your view on this? That whether obligation first, then power, or power first, then obligation? Current debate is focusing on power, limiting the power, creating the power, right? Why power? What for? So, my view is obligation first. And when obligation is to be carried out either by the legislature or by the executive or by the judiciary, right? They have to have power to carry out those obligations. So, how much power they should have? Only as much as is necessary to carry out those obligations. Right? Power not for power's sake. If we are talking about power's sake, then it is not constitutional. Right? It is not constitutional. So, I would like to hear some response on this point, that whether the current debate about constitutionalism, which is power centric, right, or should it be obligation centric, right? Obligation of the state. I'm not using the word responsibility. I'm not using the word duty, right? Because the moment we say duty, the question of enforceability by the court also kicks in, right? So you must have read H.L.A. Hart, who makes a distinction between being obliged and having an obligation. Anyone who can explain why I'm doing so, and why I want to hear from you. Remember one thing, that the age you are in, this age is more creative, right? You are more energetic. You are more exposed to technology, right? You have your own mind. So, should we talk about power first, then obligation, or obligation first, then power? Anyone?
Sir, according to Gandhian principle, uh, Gandhi used to tell that duty first, then rights. But you changed the dimension from duty to obligation. But I couldn't. We couldn't find a proper thing, sir. So, sir. Yeah, because in scriptures, in every scriptures and religious laws, also saying that duty first, then rights. Uh, yeah, so people
And that is
adopted
why,
that rights first here.
number one, I'm not
Yes,
talking
yes, sir.
about right. I'm not talking about right, number one. I'm not talking about duty. I'm not talking about responsibility. I'm talking about obligation, right? Number one,
Yes.
obligation of legislature. And why I'm using the expression, somebody is talking. Please switch off your audio if you are not asking a question or making a comment. Right? Let us utilize our time. Um, all of us have something else to do also in life. So if we are here for some time, let us use it. Right? Why I'm saying obligation of the legislature? Anyone who can tell me the meaning of legislature and functions of legislature?
Making laws and ensuring making laws
If the
is bad definition.
legislature number one is a body consisting of elected representatives. I'm speaking in a democratic setup, right? And those elected representatives are most reasonable men and most reasonable women, right? And they are not merely reasonable men and women, but they are most reasonable men and most reasonable women. And they do most reasonable thing. They do not merely do reasonable thing, but they do most reasonable thing. And they do so in the most reasonable way, right? For example, if the legislature is not making a law and if it is a duty, right? Somebody can go to the court and say that, look, court should issue a direction to the legislature to make such and such law, right? Court cannot do so. We have the idea of separation of power, right? And that is why I'm using the word obligation. Is it clear, Ms. Amina Tawfiq? Right?
Sir, I have a doubt, sir, because the obligations are in the DPSP, the Directive Principles of the State Policy, that is not justiciable and not enforceable by law, I think. But how can we ask direction? Even UCC, the lots of petitions there, but UCC can be how can we do that exactly? Yeah,
Very
we
good
have
question.
separate. Yeah, if
Very
fundamental
good.
rights are violated, we can go for direction or something. But if there is no
So they
law,
are DSP,
advice.
directive
Yeah.
principles are number one. They are not
Yes.
in the nature of obligation. Please understand.
Yes.
They are principles, right?
Okay.
And let us be clear about the words, right?
Yes.
Number one.
Yes.
Number two, I'm not talking about fundamental rights. I'm not talking about directive principles of state policy. What I'm saying, I'm talking about obligation and power. I repeat my first premise, what I said, what is the current understanding? What is the current debate about constitutionalism? As I understand that the current debate of constitutionalism is power centric. Pick up any article, any book. What they tell us that limiting the power of the state, limiting the power of the government, right? Some also say that constitutionalism is also about giving power to the state or giving power to the government, right? And that is why what I said that the current debate about constitutionalism is power centric. What I am saying that the debate about constitutionalism should be obligation centric rather than power centric. Why? These organs of the state, right? Legislature, executive, judiciary, right? From top to bottom, right? From top to the bottom, right? President of India, okay, just a quick general knowledge question of law. Um, who is head of state in India?
Sir President,
Very good.
according to the Constitution,
And who is head of the government, central government?
Sir,
Sir
Prime
Prime
Minister.
Minister, nominal head.
Prime Minister.
Yes, sir.
What is the basis of that? Answer. As she said, Constitution. What is the legal basis of your answer? Head of central government means the President of India. Read the General Clauses Act 1897. And this is again a misunderstanding. There are so many misunderstandings, right? The General Clauses Act, right? Section 3, subsection 8, if I'm not mistaken, but maybe that number I'm not able to recall correctly, right? Head of the central government is defined. And the meaning of central government is, central government means, right? Before the commencement of the Constitution of India, this, and after the commencement of the Constitution of India, the President of India, not Prime Minister, not Prime Minister. So from the President of India, and President of India is part of the legislature as well as executive head, right? Both, right? Both. So from the President of India to the last person in the executive and last person in the executive. Similarly, in judiciary, right? Chief Justice of India and the peon, right? Amin, Peshkar, Ardali, orderly, everyone, they're part of judiciary, right? So when we talk about judiciary, we should not be talking only about the judiciary and as an institution and judiciary as judges, right? There are other players in judiciary who are officers. So they are also part and parcel of the judicial system that we are having, right? So what I'm saying, I again say that obligation, legislature has certain obligation, right? What are the obligations, right? And what I'm saying that the debate must shift from being power centric to obligation centric, right? And then these organs should be given only as much power as is necessary to carry out those obligations, right? Now, since this is my idea, and this idea I have not spoken anywhere else before, right? So for the first time, I'm making this idea of mine public in this forum. Without this idea now, the audience, they are expected to question that idea, right? If you have a disagreement, you question that idea. No, we are happy with it, and this is how it should be. That let us focus on power. My point is, why power? Why power? Only for the power's sake, right? No. Judiciary, legislature does not need any power. Executive does not need any power. Judiciary does not need any power. But for what? Just to carry out the constitutional obligation that they have. Right? That they have. And then the question is that if that be the case, how much power is necessary? Right? If you have read two decisions of the Supreme Court of India, latest one was the Tribunal Reform Act, right, where certain provisions of the Tribunal Reform Act have been declared unconstitutional, right, unconstitutional. And the last one about where it is a Constitution Bench decision, the reference that was made by the President of India to the Supreme Court under Article 143 of the Constitution of India, right? So, what is that, right? It is about the power of the governor or power of the president, right? That whether the president, if there is an assent by the governor to a bill, no problem, right? If it is withheld, can it be withheld till eternity? Simpliciter, right? Whether or and if it is reserved, right? Can it be reserved till eternity, right? So one thing what the Supreme Court of India has clarified without reopening the Tamil Nadu judgment, because judgment was not reopened in personam. Only the interim part of Tamil Nadu, state of Tamil Nadu has been reopened by the Supreme Court. Because in a reference matter is not an appeal matter, right? Reference matter is not an appeal matter. So in reference, there may be an overruling, but there cannot be a reversal. So anyone being law students who can explain the difference between overruling and reversal? find that out, right? If you do not know, look, nobody knows everything, right? Always ask yourself that when you read anything, when you listen to anyone, whether some questions are occurring to you or not. That is the mark of an intelligent mind, and that is not my idea. Somebody else has said it, right? If the questions are not occurring, right, then there's a problem, right? If the questions are not occurring, maybe that person is designed or cut to do something else, right? To do something else. So reversal, it's different, right? Overruling is different from reversal. So here, there may be overruling in reference, right? But there cannot be a reversal. Concrete judgment in personam cannot be reopened in a reference matter, right? What can be answered and cannot be answered, though the Supreme Court of India is not bound to answer, the Supreme Court of India is not bound to even entertain that, right? Even when it entertains the reference, right? Even then it may refuse to answer the question, because that, as the Supreme Court of India did, how many questions were referred to by the President of India to the Supreme Court? Anyone quickly? How many questions were referred to? How many of you? Because this is what I'm asking is a newspaper based question that does not require one to read the whole judgment. Are you getting my point? 14 questions. 3 questions, the Supreme Court said, no, we are not going to answer for reasons recorded by them. Simple. Right? So, again, coming back to the main proposition that I was making, and the proposition is that debate about constitutionalism should shift from being power centric to obligation centric, right? Obligation first, power later, right? Why and how much power? Only as much as is necessary to carry out. I'm not using the expression discharge. I'm not using the word perform. What I'm saying, to carry out the obligations. Nothing more, nothing less. But there's no mathematical formula, right? Mathematical formula. So what the Supreme Court did only a few days ago, that look, if you are withholding it, right, then you have to return it with your suggestions. You cannot sit upon it. Are you getting my point? So any difference of opinion, look, we learn more by disagreement, by disputation, by disagreeing, by speaking, or else I will not know if anyone is following me. That are we wasting our time? Are we utilizing our time? Right? So whatever you may agree, you may disagree. If you agree, you have to have some additional reason of your agreement. Just merely saying that, sir, I agree with you. No, I don't like my audience to agree with me. If you disagree, again, equally with reasons, right? So anyone? My advice to all of you is that speak, right? And no question is a stupid question in a discussion. It should be according to your best judgment. And then don't care about it. क्यों तंजील कोई कुछ कह क्यों नहीं रहा है? Do you follow Urdu Hindi? I can also, I'm equally comfortable to speak in Hindustani. We'll be using English
Good
words
evening, sir.
wherever necessary.
Good evening, sir.
Yeah, please go ahead.
Am I audible?
Yeah.
Yes, sir. Thank you for the session today. And I have just one question.
Mhm.
So, when we talk about constitutionalism and the rule of law, so how do you explain to us the provisions of Article 361 of the Indian Constitution
Mhm.
that gives immunity to the President of India and the Prime Minister?
Mhm. 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 Immunity for what? There's a limit.
Immunity from prosecution of criminal
Can
proceedings.
can you read Article 361?
Sir, I'm not able to memorize the
No,
wordings
no,
of
I'm not
Article
saying to
361.
recall and say it. You may find it out. You can open your mobile. You can read there from. Now it is easy for us. When we were students, we have to carry the text of the Constitution or the acts. Now it is not that much of a problem, right? You can find it out quickly and you can read it out, right? Where is the problem?
Okay, so 1 minute.
Hmm. और महविश कैसे हो?
Alhamdulillah, I'm fine.
खालिद भाई आए नहीं है?
No, he's not here.
हाँ,
He was
वही तो मैं कह रहा हूँ तुमसे
जी,
कि देखो यही होता है फिर फेवरेटिज्म.
he was supposed to join, but he got stuck up. So he's apologized already that low network
नहीं
zone
कोई
में थे वो and he couldn't.
नहीं
Yeah.
नहीं कोई बात नहीं, कोई बात नहीं.
But we're
This was
having
on
it
the
live
lighter side.
streamed.
This was on the
जी जी
lighter side.
जी जी. But we're having it live streamed anyway, so
Mhm.
I'm sure that
Mhm.
the both of you will have a good discussion over it later on.
Mhm. So without that
Hello, sir.
audience ready? Yeah.
Yes, sir. Article 361,
Mm.
clause 1 says the president or the governor of a state shall not be answerable to any court
So just a
for
minute,
the
just a minute,
exercise.
just a minute, just a minute.
Yes,
When you were asking the question, you also included the prime minister, right? So again, go ahead. Mm.
yes, sir. Yes, sir.
Mm.
Shall not be answerable to any court for the exercise and performance of their powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those powers and duties.
Powers and duties as conferred on them, right? Do you know that for the president and governors, the constitution employs two terms: functions of the president and functions of the governor, powers of the president and powers of the governor. What is the difference between function and power? For duties and function, the prime minister, sorry, you said prime minister, so I, because uh, company matters, right? So if the for functions and duties, right? Sorry, for power and duties, not for functions. That is number one. Right? That is number one. That if it relates to, so anyone who can explain the difference between power and function. ये तो पूरी महफिल दूसरी लगी हुई है महविश.
Sir, we'll just instruct the
नहीं नहीं कोई
attendees to
जरूरत नहीं है.
remain.
देखो कहना आजाद लोग हैं and we are talking about constitution. Let us respect the freedom and we expect from them that we will respect our freedom also. All right. That is what a free and equal society is, right? Mutual respect, right? That we should not be disturbing them, and if they are getting disturbed by the interaction that we are having, we should stop it, right? Why should we disturb them, right? So coming back to the point, A difference between power and function. Power, meaning of power, we have just discussed. Right.
Sir, may I?
Yeah,
If
please.
Sir, power, as we have discussed, the power describes about the capacity. It gives a discretion, while the function obligates someone to
Not
do something.
necessarily discretion. Not necessarily discretion.
But sir, it gives somewhat element of discretion and it gives a capacity to do.
May,
But
may,
function,
may, may not. May or may not.
okay, sir.
But that is not an essential feature of power, that it must be having a discretion. Right?
And sir, for talking about the function, it's kind of obligation. It gives a sense of duty that you have to do this work.
When power is given, number one, as I said, to carry out the obligation, because you have to have power, because you have to change the position. And without power, that cannot be done. And that may be, so that is one. Carry out the obligation. Perform the function. Functions are performed. Right? Power is exercised. Duties are discharged. Obligations are carried out. Right? Article 74 of the Constitution of India, is it about function or is it about power? Anyone? Quickly.
Sir, Article 70 talks about the functions of the
74.
president.
74. 74.
Sir, it talks about the functions, sir.
Functions, right?
Yes,
Not
sir.
about power. And what 361 is about?
It's about powers and functions.
All right. Is it power? Whether both the words are there in 361? Power and functions, both the expressions are there in 361. Okay. You may look at that. Both are not there. So you are reading something which is not there.
No, sir,
And
it's powers and duties in 361. Powers and duties.
It does not talk about functions. Right?
No, sir.
So, what for? The president and governor, right? They will not be answerable to the court, right? Governor, please understand, is always answerable to the president of India. Governor is appointed. President is elected, though indirectly, right? So, governor, not answerable for that, but will be answerable. President is also answerable. May be impeached. Governor may also be impeached, right? But there's no question of impeachment in case of governor because at the pleasure of the president. So answerability is there. It is not that the president of India is totally and absolutely immune, right? Because how come the Supreme Court has said that, look, we are not going to answer question number 14, we are not going to answer question number this, we are not going to answer question number that, right? And read that judgment where it is saying that so far as the functions are concerned, so far as these things are, we will chip in. right? So the immunity is necessary there, because for everything, if you are dragging the governor and the president to the court, right? What for? As is given in 361. Are you getting my point? So it is not, it is, and why it is there? We, the people of India, have said so. 361 derives its legitimacy from where? From the people of India, from nowhere else, right? But whether to any extent I answered your question. I'm not saying that are you convinced that, or I'm saying that whether to any extent I have been able to answer your question.
Yes, sir.
अगर
The
नहीं तो
the
भी बता दो.
the
Yes,
point
please go
was
ahead.
yes,
Uh,
the point that I got was that the president is not absolutely immune from answering questions. I think that answers the question, sir. Thank you, sir.
okay. Anything else? Mavish, can we now open it for question answer?
Definitely, sir. Definitely. The attendees are requested to either drop their questions in the chat box and we'll take up from there, or they can switch on their cameras and mics and ask the questions directly.
और नहीं है तो भी कोई बात नहीं है.
Um,
हाँ, तो
we are waiting. Waiting for the questions. The attendees, the floor is open for the question and answer round.
Also, for the cost of repetition, for anyone who wants to ask the question, it will really help if you keep your cameras on and like ask the question that you're wanting to ask.
दबा धान.
Yes, Mr. Tawfiq Ahmed, if you want to ask a question, please.
Sir, in this case, last case we have discussed that the immunity of president. Now, how the Supreme Court entered in the intervened into the governor's matter, president's matter, how it was taken, sir. So that was my question. In this case, Tamil Nadu government,
In fact,
the bill,
I answered that question, and my answer is that please read that judgment.
okay, sir. Sure, sir.
Because one thing I must tell you that in higher education, right, or in any education for that matter, that the method of spoon feeding, particularly in higher education, must come to an end, right? Learners must try to learn on their own, right? Classroom or discussion such as these should not be speaker centric, rather participant centric. But unfortunately, this is what the scenario is, that participants, they join an event, and I often wonder what for. Some of them are really interested, but very few, because Mr. Tawfiq was the only one perhaps who asked the maximum number of questions, right? There are so many others, but that is again, I'll say that their choice, right? If they don't want to interact, What can we do? We are free people. If there is no question, let us say goodbye.
May I?
Yeah, please go ahead.
Sir, as we were discussing about the power and the function of the president, then the discussion came about the Article 74. And when we look Article 74 and with collaboration with the Article 60, which says about the oath and affirmation of the president.
Hmm.
In Article 60, there is a word that the president will protect and preserve the constitution, and where we read the Article 74, it says to act the president by the aid and advice on the minister. So what is the relevance of the Article 60? What is the meaning of the word preserve and protect the constitution?
The
That is
answer,
creating a contradictory.
no, no, it is not. It is not. Can you read Article 74? Answer is in Article 74. Read it,
Okay, sir,
and
just
let us see that whether any of the participants can find the answer in Article 74 for the proposition that the two articles are not contradictory, right? They are not contradictory. So let us do this exercise. All of you should read Article 74, and because we had a discussion a few minutes ago, I have indirectly answered that question at an abstract level, and when we have to concretize that answer here for the specific problem, that Article 360 is saying this, Article 74 is saying this. So read Article 74, whole of it.
Sir,
should I
then
read it aloud?
Read it aloud. Yeah.
Sir, Article 74 says Council of Ministers to aid and advise President. Article 74, Clause 1, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice, provided that President may require the
Just
Council
a
of
minute.
Ministers.
Okay. Now read the oath of the president.
Okay, sir.
The text that you read.
Sir, Article 60, oath and affirmation by the President. Every President and every person I, AB, do swear in the name of God, solemnly affirm that I will faithfully execute the office of President or discharge the functions of the President of India, and will do the best of my ability to preserve, protect, and defend the Constitution and the law, and that I will devote myself to the service and well being of the people of India.
Okay. So anyone who can find the answer, that there is no conflict between the two? Anyone? Mahvish, where are you?
Sir, I am here in the meeting.
So can you? Okay.
Sir, if I may.
Yeah, please.
Sir, essentially, from my understanding, I believe that Section 74 only substantiates the oath of the president, that if the president is to protect and preserve the constitution, he should act in
No,
furtherance of
my
the
advice to you is that the answer is in the text of Article 74. How can you use the text of Article 74 to answer this question?
I don't know, sir, that.
One thing is preserve the constitution, right? He's taking the oath to preserve, right, the constitution. And there he is bound by the advice of Council of Ministers to do what? To discharge the function, not to discharge the power. So in exercise of his power, he will preserve the constitution. Because for the exercise of his power, wherever the word power is used in the text of the Constitution of India, right, there the President of India is not bound by the advice of Council of Ministers. He is bound by the advice of Council Minister only if a function is to be discharged. Are you getting my point or not? Because read 74 again. Preserving the Constitution, right? He has the power. There are several articles using the expression power of the president or president shall have the power, right? So the power of the president is not the function of the president. President of India is bound by the advice of Council of Ministers when he or she is discharging function. Whether Article 74 uses the expression power also, and if it does not, can we read it in Article 74? Simple answer is no, we cannot. Right? And why the Constitution use both the expression in the text of the Constitution, power and function? Whether the members of the Constituent Assembly were oblivious of the difference between power and function, that they thought like it and they used power at times, they used function at time. So is that the case? No. No. Right? Because no word, please understand, even in an ordinary statute, is a surplusage. There's a very, very strong presumption against surplusage. I do not know if you know this presumption, right? But there's a very, very strong presumption against surplusage, right? So if the word function is preservation, that I have preservation is necessarily something like protection, though there's a difference between preservation and protection. I'm not going into the semantics of it at the moment, but there's a difference. So when we are talking about preserve, that I have taken the oath, right? I have taken the oath to preserve it, right? So now the point is that everyone, every holders of the constitutional office, every holder of the constitutional office and every holder of an office under the constitution, right, has to go by the constitution, right? So if advice is about discharge of the power, and please never ever confuse theory with practice, right? Never ever judge a theory, right, with the practice, right? Practice is judged in the light of a theory. So what is the constitutional theory on this point? The constitutional theory on this point is that the President of India is bound by the Council of Ministers only if he or she is discharging the function. Does not mean by any stretch of reading of the provisions of Article 74 that the President is also bound by the advice of Council of Ministers to um, exercise his powers. Power is exercised without the advice. And if the President of India chooses to exercise the power also because of the advice of the Council of Ministers or of Minister, that's a different take. Right? But if an idea isn't there in Article 74, if a word isn't there in Article 74, can we read that? Simple answer is no. It can't be read. Right? So, that is my take on this. And two, whenever there is a question, there is also a presumption against overlapping. There is also a presumption against conflict. There is also a presumption of constitutionality of every provisions, including the provisions of the Constitution and of ordinary legislation. Right? So, do you find any merit in my response? Because it's not that I'm saying so, therefore you must necessarily agree what I said. I'll be happier if you disagree more, if you dispute what I am saying. And you say, sir, or Professor Alam, I do not agree with you because of following reasons. Right? This is how we sharpen our intellectual capacity. Right? By asking questions, by disagreeing, by disputation. Only thing is, for any meaningful discourse, dignified discourse, some decorum is required. Right? For online interaction, one of the decora is that at least the participants must be visible. That it's virtual. Virtual does not mean an empty screen. Right? So now I can see at least some faces here. So thank you. Any other question quickly? And whenever the time is over, I request the organizer to let me know. I'll immediately sign out.
No, so the time runs at your discretion. We will not want to keep you longer than you would want to stay, but not the other way around.
So any other question?
Sir, I have a question if I may be allowed.
Please go ahead, Tanzil.
Sir, it's completely in the context of constitutionalism that I'm asking this question. That how do we protect it against the efforts of an unruly state that is hell bent on deteriorating and sort of derogating the constitution itself? Can we use the sword of constitutionalism as a shield?
It is a continuous struggle, right? It's a continuous struggle. We are a democracy today. We are a republic today. We are sovereign today. We are socialist. We are secular. It didn't come for free, right? People have sacrificed their life, right? And have sacrificed many things. So freedom didn't come on a platter, right? There are so many freedom fighters who are known, and there are many who are unknown, right? Many foot soldiers, even their names are not recorded anywhere. That who were they, right? So people, right? And then there are one is no doubt court, right? Judiciary, and then constitution is mainly political, right? We cannot understand constitution, constitutionalism, law of the constitution, or without understanding the politics of the time, right? Question is, most of the people are politically correct, or they try to be politically correct. Very few are politically erect, right? So it is a continuous struggle. So one is legal way, legal method is legal method, going to the court, right? And what for one can go to the court, right? You can a law, not a law, not merely a bill or an act, a rule, a regulation, bylaws, the constitutional validity of that can be challenged, right? Number one. Number two, executive may also be taken to the court for inaction, for right. So people have to uh, participate in that. And the biggest problem, as I understand, is silence of the majority. Most of the people think that how does it matter to me, right? How does it matter to me? I'm not directly affected, right? How many of you have watched Jamtara? What is the tagline of Jamtara series?
Sir, it says सबका कटेगा. जामतारा सबका कटेगा. It's basically
सबका
based
number
on some.
आएगा, something like that,
Yes, sir. सबका नंबर आएगा.
right? So it's a matter of time, right? So when we are talking about equal society, we are talking about free society. Who is free? Who has the ability to keep it? Remember, freedom comes with responsibility. Otherwise, it is anarchy, right? Do I have the capacity to keep my freedom, right? Am I willing to make sacrifices to keep my freedom? It's not free. Freedom is not free. Please understand. Freedom is not free. It didn't come for free, and it will not stay for free. One has to pay for it, right? So when sitting in a drawing room like we are discussing, because we are talking about constitutionalism, right? Then political method, no doubt about it is, and opposition. Opposition has to play a role in a democracy, right? A democracy is strong if the opposition is strong, right? So if opposition is not strong, right, If the opposition is sleeping, right? So that is political method of preserving the constitutionalism. And when we talk about Constitution of India, please remember Constitution of India is plus minus the text of the Constitution of India. That there are certain things in the text of the Constitution of India, but they have been declared unconstitutional by the court. There are certain things which are not written in the text of the Constitution of India, but they are in the Constitution of India. So it is not merely the text, right? And it is evolving, no doubt. Everything evolves, right? Evolve. We are also evolving. And what is the end of evolution? Death, right? Because we cannot understand evolution unless we also talk about or think about death, right? It may be complete, it may be partial, but it goes on, right? So political method, opposition, right? In our democracy, legal method, judicial method, then media, right? Poets, right? Like uh, amendment to the Constitution of Pakistan, recent amendment. Anyone who has any idea about that amendment? What is that? What it did? Right? Is it in consonance with the constitutionalism idea of constitutionalism? During Ziaul Haq, Constitution was amended. Right? And then Habib Jalib wrote something on that. That is very popular. Right? And what Habib Jalib was talking about, Habib Jalib was also talking about constitutionalism. Right? When he said, ऐसे दस्तूर को सुबह बेनूर को मैं नहीं मानता मैं नहीं जानता, right? दस्तूर, आइन, right? संविधान, constitution, right? It doesn't mean that. And why do we have basic structure? Why do we have basic feature? What it does, it limits the power of the parliament and state legislature. You can't do this, right? You cannot destroy it, right? So power to amend does not mean power to kill. That constitution cannot be, because we have to carry out the obligations, right? That is, so how can it be done? It has always been challenging, right? It has always been challenging. It's not that there's something new. Things have been happening, right? But then role of opposition, role of lawyers, role of judges, role of teachers, role of students, role of media, role of poet, role of writers, and every other person in the society. Are they thinking about, we are having a discussion on constitutionalism, and out of 38 participants or so, how many are really interested in this discussion, right? I hope that everyone, right? We are discussing this point for almost 90 minutes, if I'm not mistaken, almost 90 minutes, right? We can go on discussing this, right? My advice is that read, think about it. And if we are talking about constitutionalism, freedom, and we think that it will, I'm free, what I'm doing for my freedom? Am I working for it? Can I keep it? Right? Can I keep the constitution? How long will it survive? Depends on the people. Do they want to keep it? Right? So how can that be done? Because what we are talking about soft power, hard power. What happens in the classrooms? Right? Are we merely reading the text? We must read the text. As there was a question that there is a seeming conflict between these two provisions of the Constitution of India. What I read it, right? There's a presumption against conflict, right? There's a presumption against conflict. They are parts of a whole, right? And when there are parts, it's a constitution, whole constitution. There are several provisions. What they are part. They are coordinate. They are helping each other. They are helping other provisions, right? So that is my take, Tanzil, on this. Yeah. Anyone else who would like to say something on?
Yes, sir. Good
Please.
evening. Yes. I have some confusion with Article 22 that talks about a suspect being presented to court within 24 hours, and the same Article 22 talks about prevented detention. And holding to the fact, the issue of writ of habeas corpus that talks about keeping someone in detention beyond the statutory time. So it's confusing to me. I want to know. Also, one asks whether Article 22 is not violating Article 32 that talks about the issue of writ of habeas corpus that gave the power to the Supreme Court to issue that writ. That's my question. I want clarity because it's confusing me.
Look, number one, read the whole of Article 22, and there are several judgments of the Supreme Court of India, particularly, and I'm not talking about high courts, delineating the law relating to preventive detention. That there are several checks that must be used before somebody must be put in preventive detention, right? No doubt, in every society there are all type of people. There are good people, there are bad people, right? There are some who are dangerous. So there are certain norms which are prescribed in 22, and they have also been interpreted, constructed by the Supreme Court of India. All right. Problem arises when somebody is detained and the whereabout of that person is not known, or it is not known that whether it has been detained by the state or has been taken away by somebody else, right? So Article 22 itself is very detailed one, right? And it's a fundamental right. It's a right against preventive detention, right? It's a right against preventive detention. So, since it is a right against preventive detention, so there cannot be a conflict between 32 and 22. 32 is also a fundamental right. 22 is also a fundamental right. Both are rights. But at the same time, like right to life and personal liberty, right? No person shall be deprived of his life and personal liberty except according to the procedure established by law. In a sense, it means, in a sense, not in every sense, it means that anyone can be deprived of his life and or personal liberty according to the procedure established by law. Right? The only thing is that it must be a procedure established by law. And that procedure established by law in India means not any law, not merely lex, but also use or juice. It must be just, fair, reasonable, non-arbitrary. That it's not that you can do anything that you like. Correct? So that's my response to your question. Sam. Anything else?
Thank you so much, sir. If the participants have any other question,
वैसे भी अब मेरा डिनर टाइम हो गया है, मैंने दवा
yes, sir.
खा ली है, तो अब मैं, क्योंकि अब क्या है ना, अब नहीं तो मेरी क्लास यहाँ शुरू हो जाएगी, फिर बचाने
Definitely,
मुझे
sir.
आएगा नहीं.
Yes, sir. Definitely, sir. So, Professor, I have a confession to make. I began by quoting Shakespeare. That was a prepared speech. But throughout this lecture, I end this lecture by, I am more curious than I was before regarding this topic. So I believe that an appropriate end to this would be quoting Iqbal, who said, "जहां में अहले ईमा सूरत खुर्शीद जीते हैं, इधर डूबे उधर निकले, उधर डूबे इधर निकले." Professor Ghayur Alam, thank you so much, sir, for joining. Virtuosity Legal is already indebted to you, have you as a senior editor. We are now more indebted for all your insights that you have shared with all of us. Thank you so much, sir.
Thank you. Thank you, everyone. Thank you. Good night.
Thank you so much. Thank you.
I would now like to invite our project manager to deliver the vote of thanks, which will be followed by the valedictory ceremony.
Thank you, Avi. As the curtains draw to a close on this enriching chapter of Virtuosity Lexicon, to stand before you and extend our deepest gratitude on behalf of the entire organizing team. What began as a vision to celebrate the boundless beauty of law has blossomed into an unforgettable tapestry of ideas. Virtuosity Legal went live for the world on February 8th, 2025, and has ever since seen a slow but a steady growth. From numbers to words of appreciation amongst the peers, Virtuosity Legal has made a small but an impactful mark in the legal discourse. Hereon, the future is bright. We extend our gratitude to the people of the fraternity who have not only been kindly accepting but also extremely appreciative of our humble efforts that bears no institutional affiliation. Virtuosity Legal exists as an independent student run initiative, and it is a collective win for the students, fraternity, are at it to achieve. Before we part ways, allow me to extend my heartfelt gratitude firstly to our patron. Your constant support and guidance has been the pillar on which the lexicon stands today. To Ms. Atika Jahan, Managing Director of ODR Nexus, thank you for your invaluable partnership and unwavering encouragement. A huge thank you to founders of Virtuosity Legal. We are genuinely so grateful to you for trusting us with this opportunity. More than anything, thank you for giving us a space where we can work without stress, where it truly feels like a family, and where every day becomes fun because of the environment you have built for us. And finally, a very special appreciation goes to our conveners of various events. For Orathon 1.0, Gufran Ahmed and Muhammad Azair Khan. For Deep Shield 1.0, Arisha Malik. For Verdictum 1.0, Alvia Imam and Nashra Naeem. For Lexicon First Arbitration Moot Court Competition, Khan Muhammad Ubeda and Junaid Usmani and Akshat Pahuja. Each of you has worked tirelessly behind the scenes, ensuring that every detail, every transition, and every moment throughout Lexicon was seamless. As we log off from Virtuosity Lexicon 2025, let us carry this enriched lexicon we have forged, words of equity, precedent, and reform, into our work and our future. With gratitude that runs deep, thank you for making Lexicon
Yeah.
not merely an event, but a legacy. Thank you.